Yes, have a seat, everybody. Good afternoon. Now I'm going to invite Ms. Cherry Casey to make submissions on behalf of the court participants represented by Levy and McRae. Thank you.
Thank you, sir, and good afternoon. And good afternoon to everyone else who's present here. My name is Joanna Cherry, and I appear as Senior Counsel for the core participants who are former patients of Mr. Eljamel and for their personal representatives, which I will refer to in my submissions as the patient group. I'm assisted by my learned junior, Claire Connolly, and we're looking forward to working with the inquiry to assist it in discharging its terms of reference. And we seek to ensure, above all, that there's effective patient engagement, both in respect of the inquiry, but also in respect of the independent clinical review. We are, sir, acutely conscious of the importance of this process to those whom we represent. Many of them have suffered catastrophic injury and psychological trauma which is ongoing and which may be exacerbated by their engagement with the public inquiry and with the independent clinical review. We were very pleased this morning to hear counsel to the inquiry acknowledge the long and hard fight that has produced this public inquiry. Now that we are all here, we want to work in collaboration with the inquiry to ensure it can fully fulfil its terms of reference, and we welcome this opportunity to make oral submissions at the preliminary hearing. These are in addition to the written submissions which we submitted in advance, and I'm very grateful to counsel for the inquiry for his very full engagement with many of the concerns that we set out in those written submissions. What I have to say this afternoon is grouped under the same two chapters as were in the written submissions. The second chapter will deal with some issues arising from counsel's note. Many of those have been dealt with this morning to my satisfaction, but I still have a few points that I wish to make. But perhaps most importantly, chapter 1 of what I have to say addresses the main concern of the patient group, and that is the extent to which they will be involved in a patient-centred and trauma-informed process, and the extent to which it is recognised that the group will require adequate support and assistance for their legal team to engage with both the independent clinical review and the public inquiry. Now, in my written submissions, I said that there had been a lack of clarity over the patient-centred and trauma-informed approach. But I'm very grateful to Senior Counsel to the inquiry for the clarity that he has provided this morning in relation to the engagement process that the inquiry intends to undertake in relation to the issue of providing support and psychological support and a trauma-informed approach. This, of course, should be at the heart of both the inquiry and the independent clinical review. That is what the Cabinet Secretary promised on 7th September 2023 when he set up the public inquiry and said that the independent case review would run alongside it. He said, and I quote, "That will allow a patient-centred and trauma-informed review of each patient's clinical case." The Memorandum of Understanding between the independent clinical review and the public inquiry also recognises in Principle 11F that both processes require to undertake their work in a trauma-informed way. And of course, paragraph 91B of Counsel to the Inquiry's note reaffirms that a trauma-informed approach is central to the work of the inquiry. We are very grateful to Counsel for the clarity he provided this morning about the inquiry's patient-centred and trauma-informed approach, but we still have some concerns. In particular, firstly, we are concerned that the provision being made available to support the patient group through the independent clinical review process is not sufficient to enable their legal team to provide the advice and advocacy necessary for them to participate in the independent clinical review effectively. And secondly, we are concerned at the absence of any provision of funded mental health support for patients to participate in the independent clinical review process. Now, sir, separately, you will be aware that those instructing me are in correspondence with you about what they perceive as a lack of flexibility in the arrangements envisaged by the Section 40 award made in respect of the patient group's legal representation. And all I will say about that is it needs to be borne in mind that those instructing us are, unlike the inquiry legal team, not engaged full-time on this inquiry and have responsibilities, professional responsibilities to other clients as well as their professional responsibilities to the patient group. But the focus of what I have to say relates very much to the independent clinical review, subject to one or two provisos. Now, having met with most of the patient group in consultations last week, it is very clear to myself and my learned junior that proper support from their legal team is absolutely necessary, not only due to the cognitive impairments which they suffer, but also because of the potentially re-traumatising impact that engagement with the independent clinical review may cause. And this will require access to funded mental health support for extremely vulnerable individuals, as has occurred in other similar processes. Most of the patient group have suffered serious mental health consequences following their engagement with Mr. Eljamel and NHS Tayside. These include, but are not limited to, post-traumatic stress disorder and suicidal ideation. The process of engagement in both the independent clinical review and the inquiry is potentially re-traumatising patients who have already been denied their voice as legitimate complainers for many years by both Mr. Eljamel and NHS Tayside. Paragraph 33 of Counsel to the Inquiry's note acknowledges representations of concern that have been made in respect of the independent clinical review and sets out how those particular concerns, for example, in relation to incomplete medical records, will be resolved by reference to GP records. Now, this section of the note states that the patient experience will be captured, but we submit that the complexity of this process, and most importantly, the trauma resulting from patient re-engagement, has not been properly recognised and is not provided for in the proposed model of patient support for the independent clinical review. Inadequate funding for the legal support of the patient group in the independent clinical review is a concern, and I'm afraid to say it has also been a concern in relation to the inquiry. And we raise this because it could undermine the aspiration for a patient-centred and trauma-informed approach. In relation to the inquiry, it has been stipulated that all affected patients must be represented by one law firm. But the legal team at that law firm feel that they're not being afforded the flexibility in the funding award to meet their professional obligations to the patient group and their other clients. A further concern is that there has already been one attempt to restrict the ability of the patient group's counsel to consult with them in a meaningful way. And this occurred when those instructing me made an application for funding for the first part of the inquiry and received a letter dated 13th August from the solicitor to the inquiry saying that the application sets out that it is intended that there will be consultations with patients led by counsel and that each consultation would be with a group of 10 patients. The inquiry does not consider that this is a necessary or economical approach and that instructions can be obtained from solicitors in the normal course, who would thereafter provide instructions to counsel, subject to the general requirements under paragraph 44 of the Legal Expenses Protocol. And I'm afraid to say, sir, it took an online meeting to confirm that I and my learned junior could indeed consult with the patient group in advance of this preliminary hearing. However, we were advised that there was no guarantee that there would be any payment for consulting with the patient group, and that any payment would be at the discretion of the inquiry. Now, this is really quite extraordinary, sir, because on no reasonable basis can counsel be expected to fulfil their legal and ethical obligations without consulting with the patient group. And whilst we do appreciate that for very good reasons there are limitations to recovery of fees for reasonable and necessary work, we cannot see on what basis client consultations could be regarded as other than reasonable and necessary, particularly in the circumstances I have outlined. And we very much hope that this will not be a problem going forward. But I return to the main concern, which is the issue of the independent clinical review. Those instructing me were initially informed that there would be no role for legal representatives in respect of the independent clinical review. When it became clear that patients' statements to the independent clinical review may form the sole evidence to the inquiry for many patients, those instructing me pushed for the patients to have the support of their legal representatives within the independent clinical review process. It was felt that this would be particularly necessary in relation to the provision of statements and advice to people in the patient group on issues of consent and privacy. It is understood that the Scottish Government intends to commission the Citizens Advice Bureau Patient Advice and Support Service to provide what they describe as a bespoke service to assist the patient group with the independent clinical review process. My agents have asked for details of what this service is expected to consist of and how patients might access it, and they have been advised by the Government that this package has still not been finalised. We are, sir, particularly concerned that the Scottish Government intend to involve the Citizens Advice Bureau in the provision of support to patients who already have legal representation. We do not consider that that is appropriate, and furthermore, we fear that it risks further re-traumatising patients by their involvement with yet another third party with whom they have not yet met. In the meantime, those instructing me have received confirmation from the Scottish Government that they are willing to provide limited funding for legal assistance in relation with the independent clinical review, but only strictly in relation to points of law that may arise in the course of a former patient narrating their experience, or a review of statement for points of law, or review of patients' individual reports when issued to provide legal advice. The Scottish Government remain of the view that the redrafting and assistance with drafting of statements and questionnaires would be provided by the Citizens Advice Bureau. They also insist that medical records will be recovered by the inquiry and sent to the independent clinical review and on to the neurosurgeon without the patient group seeing these prior to providing those statements. Now, whilst this is a very unsatisfactory state of affairs, those instructing me in the spirit of trying to move forward have agreed to that limited funding on a trial basis. However, they're waiting for that agreement to be formalised by the Scottish Government, and they understand that a number of steps require to be completed by the Scottish Government internally to ensure compliance with government financial controls. And there is, I'm afraid to say, at present, no clear information available from the independent clinical review or the Scottish Government on what mental health or counselling support the patient group will be afforded during this process. So to summarise, sir, despite extensive correspondence with the Scottish Government in their capacity as sponsor of the independent clinical review, and indeed of the public inquiry, those instructing me do not as yet have sufficient reassurance on the issue of legal support for the patient group in the independent clinical review. Some considerable reassurance was afforded on other matters at a round-table meeting which those instructing me convened last week with representatives of the public inquiry and the independent clinical review. And as you have heard, sir, from counsel to the inquiry, that meeting took place on Friday. Unfortunately, the Scottish Government declined to attend, citing the fact that they were a court participant in the inquiry, despite it having been made crystal clear that they were invited in their capacity as a sponsor. And I'm sorry to say that we have found the approach of the government to the whole matter obtuse, and I would wish to associate myself with what counsel to the inquiry said about the need for the Cabinet Secretary to get this matter sorted out without further delay. We absolutely appreciate that these problems that I've outlined in relation to the independent clinical review cannot be resolved by either the chair of the inquiry or the chair of the independent clinical review. But the failure of the Scottish Government to resolve these issues jeopardises both processes and will cause unnecessary stress and trauma to the patient group if it's not sorted out without further delay. Those instructing me are simply concerned to be able to provide effective legal representation to the patient group in line with their professional responsibilities. And that is the focus of their concern and the knowledge that the proper functioning of the independent clinical review is integral to the success of the inquiry. Without proper patient engagement, the legitimacy and purpose of both the independent clinical review and the inquiry risk being adversely affected. And if both bodies wish to fulfil their commitment to a trauma-informed approach, this necessitates that patients are properly supported to engage with the independent clinical review and are provided not only with the support and guidance of their legal team, but with appropriately funded mental health support through both processes. Now, I will leave that chapter stressing, as I did before, that I understand that neither you, sir, as chair of this inquiry, nor Professor Wigmore, as chair of the independent clinical review, have it in their power to resolve the issues which those instructing me have with the Scottish Government, and it is for the Scottish Government to step up to the plate. And it's very much a matter of regret that they've not felt able to participate in this preliminary hearing in their capacity as sponsor. And it means we won't be able to move these issues forward today, but I hope that we will be able to move them forward in the days to come. I turn now to Chapter 2 of my submissions, which very much focuses on issues identified by counsel to the inquiry in his note for the preliminary hearing. I'm pleased to say, sir, that many of the issues which I and my learned junior raised in our written submissions have been dealt with to our satisfaction by counsel to the inquiry this morning. So I will restrict what I have to say this afternoon to those areas where we still have concerns. The first relates to the designation of core participants. We share the inquiry's concerns about the extent of NHS Tayside's representation of its current and former employees. We find their position, as outlined by counsel to the inquiry this morning, because we've not seen their written submissions yet, but we find their position, as outlined by counsel to the inquiry, to be wholly unsatisfactory. It raises questions as to the extent to which NHS Tayside are aware of their obligation as core participants in this inquiry to achieve its terms of reference, both in respect of current and former employees. And we are very apprehensive that this may impede the progress of the inquiry. Having considered matters, sir, we wonder if it might be of assistance if NHS Tayside, together with all core participants, were asked to produce position statements in advance of the opening statements, which are to be heard at the continued preliminary hearing. The next chapter, where we still have outstanding concerns, I've dealt with largely already, and that's the independent clinical review. But I just wanted to add one point. We did receive much reassurance last week at the round table, and we understand that the independent clinical review are indeed exploring options for supplying trauma-informed support to patients who register with the independent clinical review. However, we also understand that they are in dialogue with NHS Tayside regarding psychological support for the patient group. And I wish to take this opportunity to emphasise that the patient group as a body have little or no confidence in NHS Tayside, and that really any psychological support will require to be afforded by an independent provider. The next chapter, where we have some outstanding concerns, is approach to evidence and public hearings. We would, sir, wish to have input to the selection of patients to give evidence. We also seek confirmation that provision for a representative to give evidence includes a nominated spokesperson in line with a trauma-informed approach. We note that the General Medical Council will be called to give evidence. We would wish to know whether it is likely that somebody from the Health and Safety Executive will also be called to give evidence, given what is said in paragraphs 50 and 51 of Council's note. We wish to emphasise that issues such as informed consent and the evidence surrounding the same will not be capable of capture in a questionnaire that a patient completes without support from their legal representatives. And finally, under the heading of approach to evidence and public hearings, paragraph 59 of Council's note sets out the process whereby the inquiry will recover patients' medical and complaint records. We wish to know what system or process will be in place to enable the inquiry and the independent clinical review to ascertain the patient's acceptance or otherwise of the accuracy and completeness of their records. This, sir, is an issue of concern to many in the patient group who have become aware down through the many years that their medical records may be incomplete or that they may even have been falsified. The next chapter where we have one or two outstanding concerns is in relation to Rule 8 requests and Section 21 notices. Many of our core participant group were resident within NHS Fife's area. They were referred from NHS Fife and also received aftercare from NHS Fife. So we therefore remain of the view that Rule 8 and Section 21 notices should be served on NHS Fife to recover documents relevant to patients. We believe that this is relevant to the inquiry's systemic inquiry into the continued referral of patients to Mr. Eljamel, despite known concerns around his practice. Next, I turn to the issue of disclosure of documents. We have heard the very full explanation given by Council to the inquiry this morning of how the inquiry intends to proceed, and we're very grateful for that. We simply seek some reassurance from the inquiry that sufficient notice in advance of disclosure of documents will be provided to allow legal teams to make arrangements to provide proper consideration of the documents in advance of the relevant evidential hearings and the preparation of any Rule 9 applications that might be required. I next turn to the issue of instruction of expert witnesses. We're very grateful for the reassurance that no expert witnesses will have been or will currently be employed by NHS Tayside, nor will they have worked alongside Mr. Eljamel in the past. For obvious reasons, this is an issue of the utmost concern to the patient group. The final chapter I wish to address in relation to matters raised in Council's note is the issue of protection of information. We were very pleased to hear Council to the inquiry acknowledge the patient group's concerns about the protection of information and data protection. This is something about which the patient group feel very strongly and with good reason, given various events that have occurred in the past. But we continue to have one or two concerns about what was said about patient anonymity. As we understand it, there will be a presumption in favour of the granting of requests for patient anonymity, but that it will not be guaranteed. It would be helpful, and I'm sure of comfort to the patient group, to know in what circumstances a request for anonymity of a patient would be likely not to be granted. We also seek further clarification on the process of patients being able to review documentation, including their own medical records, in order to make a decision about applying for anonymity. This is particularly important for individuals who are cognitively impaired or those who might find the process of review re-traumatising. And clearly this is an area where support will be required from the legal team. Sir, that's all I have to say at this stage, except to say that on behalf of the patient core participants that I and my legal team represent, we look forward to assisting the inquiry in discharging its terms of reference. We are grateful for the open discussions we've had with the inquiry so far, and we very much hope that the commitment by both the inquiry and the independent clinical review to a trauma-informed approach is fully realised, and that the long-awaited opportunity for this public inquiry is not a lost opportunity for the former patients of Eljamel. And unless I can assist you further, sir, I would leave it at that for now.
Grateful. Thank you very much.
Thank you.
Now, consistent with the agenda that has been set, the next stage involves me in inviting Mr McGilvray of Morton Fraser McRoberts to speak to his submissions on behalf of the ICR. Mr McGilvray will know that a relatively brief submission was tendered in advance, and it is to that which I will invite you to speak.
Thank you, sir, and good afternoon to you all. Professor Wigmore, as chair of the ICR, is grateful for this opportunity. Professor Wigmore was here this morning, but this afternoon he has had to leave. He is operating in patients, so unfortunately couldn't stay any longer. Without in any way prejudging the task in the ICR's own terms of reference, I'm instructed to begin by expressing sympathy to all those who have experienced suffering arising from being a patient of Mr Eljamel, whether as a patient directly or indeed as the loved one of a patient. The ICR and Professor Wigmore is very aware that this suffering has lasted for many years. The ICR would also wish to pay tribute to those patients and family members who are able to assist this inquiry and the ICR with its work. Their contribution will surely provide invaluable assistance in the work of both processes. The process of the ICR has been designed to seek to minimise the trauma of those who participate, but the ICR does accept that the process of participating in the ICR itself might be triggering. Accordingly, part of the ICR's commitment to supporting patients is to publish routes of access to mental health support. The ICR, Professor Wigmore, is in discussions with NHS Tayside about that vital area. However, I have noted what Ms Cherry said about that in her submissions before me, and I will raise that with Professor Wigmore later today. The ICR has sought to assist the public inquiry in any way it can so far, and would wish to express thanks to you, sir, the inquiry's senior and junior counsel and its solicitors. All those just referred to, and no doubt many others within the inquiry who support them, have worked cooperatively with the ICR during these past 16 months or so. This has included attending many meetings and reviewing documents in which the PI and the ICR have a joint and material interest. The ICR greatly appreciates all this. By way of a very brief update, as at 3:45 yesterday afternoon, 302 people had registered with the ICR for a review. The consent forms with privacy notices pertinent to the consent forms to be sent to those who have registered were finalised on Monday. As of 3:45 yesterday afternoon, 37 have been sent out and 4 have been returned, and I'm pleased to report that all 4 give consent for the ICR to share details with this inquiry. It is anticipated that in the course of the next 2 weeks, the remaining consent forms and privacy notices will be sent out to everyone else who's participated. And unless I can give further assistance, sir, those are my submissions this afternoon.
Thank you very much, Mr. McGilvray. It would be my intention, Mr. Dawson, consistent again with the agenda that we've fixed, to ask you to reply to the matters that have been raised. I think that technically we might have afforded ourselves a break, but we're a bit ahead of time. Are you content to address matters now, or would you prefer to?
I'd be very happy to proceed just now, thank you.
All right, well, let's just do that.
I'm very much obliged to both of those who made contributions this afternoon and equally to others, as I've said already, who made written submissions. All of the matters which have been canvassed with us will be able to be taken forward in further discussion in the event that that proves necessary, but in the hope of trying to deal with some of the matters that have been raised at least this afternoon, I will attempt to do so. The position advanced by my learned friend Ms Cherry with regard to the inadequacy in her submission of the funding of the ICR as a matter, of the legal support for the ICR as a matter which I addressed at some length this morning. It is the inquiry's position that this is a matter which requires to be resolved by the Cabinet Secretary as a matter of some urgency. Mr McGilvray was able to provide an update as to practical progress with registrations to the ICR, which serves to illustrate the point that the ICR must be able to progress to its next stage, i.e. the completion of applicant statements as soon as possible. Beyond that, I think I've made the inquiry's position adequately clear. It would be wrong in my submission, sir, for anyone interested in our proceedings, in particular patients, to equiparate the funding issues for the ICR to which the inquiry has lent its support with the funding position relating to the inquiry. Counsel for the core participant patient group have seen fit in their written and oral submissions to assert that there is inadequate funding for the patient's legal representatives in the inquiry, which they claim is undermining the aspiration of the inquiry to have a patient-centred and trauma-informed approach. I must admit to finding it surprising that this issue has been raised in public, in particular given the importance of many of the other matters which might have been preferred for discussion and the fact that it does not form part of the agenda. However, as this has been raised, I think it's important that I attempt to provide some clarity around the general systems within which funding is provided for legal representation within the inquiry and the specifics of the application made by the made on behalf of the patient group. May I correct, first of all, my learned friend's assertion that all affected patients are represented by the Levy-McRae legal group. That is not accurate. They represent a large cohort of those who applied for core participant status. But as I think is apparent from the numbers provided by Mr. McGilvray, there are a large number of affected patients who are not represented by Levy and McRae. It is not clear, I should say, sir, how widespread the concern about funding is amongst patients. Though patients have engaged with us constructively in our public consultation, and many have continued to do so since legal funding was awarded, the matter of legal funding has not been a matter that has been raised with us directly by any of them. Their engagement, by contrast, has been helpful and focused on more substantive matters, such as a number of the matters which I addressed this morning. I take it, though, seriously, as Ms. Cherry has advanced this argument on behalf of our clients, that there must be such a concern. For clarity, the inquiry's ability to provide funding for legal expenses is derived from Section 40 of the Inquiries Act 2005, and the determination made by the sponsoring minister under that section, which defines the very specific rules by which legal expenses can be awarded by the inquiry. The minister's determination can be found on the inquiry's website. These rules provide that legal expenses can be awarded, but only where they are fair, reasonable, proportionate, and for work which has been effective, efficient, avoiding duplication and making the best of public funds. You must satisfy yourself, sir, as must the solicitor to the inquiry, that these conditions are met before payment of legal expenses can be made. The processes for applying for legal funding are set out in the inquiry's legal expenses protocol, which in turn includes statutorily prescribed processes from the Inquiry Scotland Rule 2007. These involve a set procedure of needing to apply for funding in advance of carrying out work and then billing for it afterwards. This process has been followed by the inquiry in relation to funding made available to Levy and McRae and their counsel. It involved an application being submitted and the chair making a determination in accordance with the rules incumbent upon him. The inquiry does provide funding for Levy and McRae's legal team, including counsel. That funding award was made in response to an application on the prescribed inquiry form. Although not required by the rules, that award was sent out with an explanation about the extent of the award in broad terms and the reasons why it was framed as it was. Again, though not also required, meetings were attended by members of the legal team on 2 occasions to help to explain what was being awarded and the rationale behind the award. It was also made clear at those meetings that your determination on that matter was final. The inquiry refutes any suggestion that this award is insufficient for the proper representation of the interests of the patient group who are clients of Levy and McRae. In particular, it is important to note that the inquiry has taken an incremental approach to the funding of the patient representative team, allowing funding in the first instance for the preliminary phase of the inquiry, which precedes the evidential phase, which is defined as when we anticipate that evidential input from core participants will become possible around December on the estimates I set out this morning. Though this was made clear to Levy and McRae in advance of them seeking funding, their application relied on the requirement for funding for certain tasks, including evidential analysis, which fell beyond the ambit of the award and were thus irrelevant to it. The written submission continues in this misapprehension about the current funding award and its temporal limitation. The submission states that the process of engaging with and accounting for inaccurate or absent medical records will be a source of great stress and trauma. Though that is no doubt correct, it appears to be asserted that greater inquiry funding is required to address that. Insofar as the inquiry is concerned, calls upon patients to provide such evidence will come at a stage beyond the preliminary funding award, given the evidential nature of that work. It is not relevant and suggests a misplaced frustration on the part of the patient core participants' legal advisors against the funding of the ICR, which is separate from the funding of the inquiry, as I have set out. During the course of discussions about funding, it was asserted that hourly rates which were awarded in accordance with your determination, sir, were insufficient, though they were at the top end of the range which you are entitled to award. That award contains full-time funding for senior and junior counsel, supervisory hours to be split between 2 partners within Levy and McRae, a full-time senior associate award, a full-time assistant solicitor award, and an equivalent award for 1 paralegal to be split between 2 people. The inquiry considers this to be an award which complies with the duties incumbent upon the chair in making it. It is known to be a larger award than was made to a similar team representing twice as many patients and 2 charities in a UK inquiry with a far wider remit than this one. It has been suggested, I think, that the award is inadequate, though no request for further hours to be covered has been made, as I understand it. In that regard, the submission is academic. No specification has been provided of what extra work should be funded, which is not currently. It has been suggested that this may result in an inequality of arms. The inquiry's position is that that is not relevant to what is an inquisitorial and not adversarial process, and in any event is based on speculation about what resource is available to other core participants. It may be a rather crude representation, but today the entire front row of the legal benches is made up of members of the patient core participant legal team, unlike benches behind it which contain multiple teams. It has been suggested that the arrangement by my learned friend, that this arrangement is insufficiently flexible. In your response to the determination, sir, you stipulated that you expected that a dedicated smaller team than had been requested, working full-time or near full-time hours, as opposed to multiple participating lawyers, would be preferable. This, one might imagine, is no less than the represented patients deserve. It is consistent with the legal requirement that duplication be avoided, which a bigger team would necessarily cause. It seems that the request has been made, though the chair's determination on the matter, as I have said, is final. The other business commitments of those who are being funded is not a matter which the chair can or should appropriately take into account. You're entitled to expect that legal representatives will dedicate themselves to the service of their clients in the work of the inquiry, which they've been asked to undertake, as I am sure they will. Mention is made of a purported restriction on counsel being able to consult with clients. There has never been such a restriction. The statutory rules and ministerial boundaries within which this and all inquiries work cannot simply allow funding to be provided by way of a blank cheque. A proportionate approach needs to be taken. My learned friend suggested that her agent suggested a guarantee of payment in advance. This is simply not how the system works, as has been explained. At present, as I have said, the work of the inquiry involves the work of the legal team to which I'm referring involves taking clients' instructions on key structural elements of the inquiry's approach, sufficient to allow meaningful appearance at this hearing and the open statement hearing to come later in the year, to contribute to important inquiry documents, including the list of issues and letters of instruction for experts. Evidential work, which will come later, will be subject to a different award. No specification has been provided as to what these initial consultations were to cover, or why their multiplicity was deemed to comply with the specified standard which the inquiry has to comply. In any event, these matters will all require to be justified when the bill comes in due course, as per the prescribed statutory procedures. In any event, we understand, as Ms Cherry has pointed out, that counsel have indeed consulted with their clients in advance of this hearing. As far as the patient-centred and trauma-informed approach of the inquiry are concerned, as I have set out, these will be advanced through direct engagement with the inquiry team, as well as via the support, which will hopefully and inevitably be provided by the patient's lawyers. As far as that aspect, involving the inquiry, of our approach is concerned, that is not dependent on legal funding. Sir, I would urge those representing the patient core participants to judge the inquiry's approach to their involvement on its substantive merits and the plans which I set out this morning. Considerable efforts have been made to seek to make it as easy as possible for patients to be involved in the work of the inquiry and to be represented. Significant efforts have been made to allow their active participation, consistent with your commitment, sir, to put the patients at the centre of the process. It is the inquiry's position that the assertions made about funding by my learned friend are baseless and, in part, based on inaccurate information. We are keen that there is clarity around this matter in case these assertions and their ventilation in public cause patients any concern or undermine their faith in the inquiry process. Everything we do and have done seeks to retain that faith and avoid those concerns within the statutory confines of our remit and the need to act in the public interest. Moving then, sir, to other aspects of the points that were raised, I'm very pleased to hear that my learned friend considered that a number of the matters she has raised in her helpful note were covered off by submissions I made earlier today. And may I reiterate, if there remain issues of concern of this nature falling out with the ambit of what I have said or have to say, we would be very happy to discuss any particular matters with her or her instructing agents on behalf of her clients. Sir, there were a number of matters that were raised, some of which I think I've covered off already, but as I had them noted, my learned friend suggested that, helpfully, that it might be useful to seek to have position statements lodged on behalf of participants, perhaps in advance of the opening statement hearing. It is not the inquiry's current intention to seek position statements. As will become apparent in due course, a number of corporate statements, as I referred to this morning, will be sought in connection with the Section 1 of our hearings, which are to some extent equivalent to what other inquiries cover in position statements.
That would deal with the perceived concern about representation, if I'm Ms. Cherry correct.
Indeed, sir. I understood her to be suggesting something more broadly from all core participants, insofar as the matter which she has raised about the extent of NHS Tayside's representation of their current or former employees is concerned. I think we are both of the same view that that's a matter which will demand further explanation by the board. And as I committed to this morning, any such response will be made available to core participants. She raised, again, the issue of mental health support, predominantly in the context of the ICR. That is a matter which falls beyond our remit, sir, although I have made a number of submissions this morning about the importance of our engagement strategy, seeking to pursue appropriate ways of patients being supported within the inquiry, which will follow in due course. As far as the evidential approach and public hearings are concerned, my learned friend has made the helpful suggestion that in certain cases it might be appropriate for a nominated spokesperson, as opposed to a particular patient, to be called upon to provide evidence to the inquiry. As part of our witness management approach, of course, it will be considered as to whether that would be a more appropriate course to take. And we will, of course, be open to suggestions made by her or by those instructing her as regards which cases would be appropriate for that type of approach to be taken. Such an approach would, I would suggest, be consistent with our desire to obtain the best and fullest evidence in as trauma-informed a way as possible. She made reference to a matter raised in the note about the GMC and Health and Safety Executive. It is not stated in the note that evidence will be given orally, necessarily, on behalf of either the GMC or the Health and Safety Executive. What's said in the Counsel to the Inquiry note, and I said this morning, is that those bodies will be called upon to provide evidence. Whether it would be of assistance to the inquiry for that evidence to be ventilated at a public hearing is a matter which will be decided at a later stage. And as my learned friend has requested, that and other questions around who may be called to give evidence will be matters upon which core participant representatives will be consulted. She made a point about what systems exist in order to ascertain whether patients accept the completeness or otherwise the accuracy of their records. As I said this morning, sir, it will be part of our remit to seek evidence relating to term of reference 14, which requires a systemic investigation into potential failures of document retention. So that will be one place in which such matters can be raised. I would anticipate although I accept that my learned friends have not seen the applicant's statement request, that any information which patients already have about issues with their medical records could competently be raised in that statement as well. I would say, connected to that as well, that the letter of instruction which has been issued for comment to core participants seeks to ask expert neurosurgeons in the ICR process whether their ability to provide an opinion on the case has to any extent been undermined by absent or absent records or other problems. So these are all places in which those issues will be able to be ventilated. She raised an issue about NHS Fife. That's a matter on which I think it may be necessary to get further information. It's very helpful that's been raised on behalf of those of her clients whom that affects. I suspect that information might best come from her instructing agents in order to understand precisely what it is that we think those records might usefully contain.
Because as I understood it, may relate to aftercare received by patients.
I think the position this morning went slightly further than the note, because the note says it relates to aftercare. My position, as I set out this morning, is if it relates to aftercare, that's really a matter for the ICR and not a matter for the inquiry. But I took it to be the case that Ms Cherry was suggesting those records may contain other useful information, which is the very subject I think we would like to explore.
Right,
what she said about the possibility of inappropriate continued referral to Mr Eljamel, off the top of my head, I think could have a relevance to the inquiry, and that's a matter which I think we should pursue. As to how many of those records, in what cases, and at what time, I think that's a matter for further discussion, which I'd be very happy to be engaged in. She asked, she made two observations relating to disclosure of documents. As I set out this morning, it would be impossible for an inquiry to set out in advance prescribed rules about when documents will be disclosed. It is, of course, the case that the inquiry will endeavour to disclose documents in sufficient time for them to be reviewed and for useful contributions to hearings to be made on behalf of core participants, in particular those whom she represents. She will recall that I have strongly urged those who are in possession of documents to produce them in accordance with the inquiry's timescales, which will be constructed with a view to making sure that the documentary product of those processes will be available in accordance with her and other core participant representatives' wishes. She made reference to the need to have documents in order to make meaningful Rule 9 applications. I make a slightly tangential, though I hope useful, point about that. In the public hearings protocol, there is set out, albeit at an early stage, the process which this inquiry intends to follow with regard to contributions from legal representatives about possible questions being asked of witnesses at oral hearings. It is her reference to Rule 9 applications relates to that area. The position in that regard is that we are going to take a more informal approach than other inquiries in order to try to maximise efficiency. And no doubt, I know that my learned friends have read the protocol, but for the benefit of others, it is our intention that proposed questions would be shared between counsel and that decisions would be made, and that as regards which questions would be asked, that there would normally be the opportunity for further discussion about questions on the day, with a formal Rule 9 application coming after that process, and very much in the hope that that process amongst counsel will result in a more meaningful contribution and discussion about which questions should be addressed. So that's rather tangential to the point she was making, but I make it in the hope that it's of assistance. As regards the protection of information and data protection, as I said this morning, Ms Cherry's reassertion that this is a matter of considerable importance to her clients is a matter which is well known to the inquiry already. It has been represented to us through various media that is the case. She's asked the very legitimate question as to in what circumstances it would be likely that anonymity would not be granted to an individual who made an application for it. And I concede that it would be difficult to envisage a situation in which it would not. given the stipulations that have been made in our existing documents. The need for there to be a process arises from the statutory rules which underpin the inquiry, and the documents which we have issued have tried to make it clear that would be the normal course in cases where applications for anonymity were made on behalf of patients. As I said this morning, that presumption, as I put it, would not apply to applications for anonymity in other cases, although, sir, you, as I know, would entertain such applications as well. Sir, those are all of the points that I was able to note down in the time. It may be that there are other matters which are left over, but as I said at the beginning, I'd be very happy to discuss those. May I thank also Mr McGilvray for his submissions, in particular his update as regards the position on the numbers registered. It's very encouraging to see, as I said this morning, that the completion of the documents which have been discussed between the inquiry and the ICR have resulted in privacy notices and consent forms being sent out, and indeed for individuals already having indicated both that they would wish to proceed to the next stage of the process, namely the taking of an applicant's statement, and also that they would be prepared to have their materials shared with the inquiry. Beyond that, sir, I have nothing to add.
Thank you very much. I'm sorry, Ms. Cherry. Well, if it's a point of clarification and brief, because it's off the agenda, and clearly there are a number of matters that have been raised that will be the subject of discussion. I have not, of course, been asked to make any ruling today in anybody's submissions, and wasn't proposing to do so.
I promise to be brief. Yes. Just very briefly, sir, just to be clear, and counsel to the inquiry said he was keen for clarity. It did not certainly mean to suggest that those instructing me represent all patients affected by Mr. Eljamel. What I meant to convey was that one law firm represents all the individuals within the core participant group, and that I hoped was clear from what I said. Second point, on the issue of funding for those instructing me, I was very careful in my oral submission to address the issue of flexibility of funding. And you will be aware, sir, that that is the matter about which those instructing me have corresponded with you in their letter of 27th August, not the amount of funding, the flexibility of funding. So it is perhaps unfortunate that we had to have such a long exegesis there on the issue of what had gone before that. I was raising the issue of flexibility of funding on my responsibility as counsel. Likewise, in relation to the issue of consulting with the patients, I read directly from a letter that was received from the solicitor to the inquiry, and I will provide the chair with that so it can be quite clear that I was raising a legitimate concern there about the issue of consulting, not about being paid in advance. If I may jest, it's a long time since I've been paid in advance for anything, Chair. It was about being able to consult with the patients, and it was being suggested that it wasn't necessary for counsel to consult and that we could just merely take instructions from our solicitor. I hope we're over that hurdle now, but again, in the interest of clarity, I wish to make that point. And finally, just to correct something that my learned friend said, the issue of equality of arms does in fact apply to inquisitorial processes. There's quite a lot of jurisprudence on that issue, particularly in light of the Hillsborough saga. So equality of arms is something which must be taken into account at public inquiries, just as in other situations. The patients have Article 6 rights there in the way that any other litigant or core participant at a public inquiry would have. And I'll leave it at that. Thank you.
Thank you very much. Mr. Clausen.
I just want to say something briefly at the conclusion of the hearing, sir. If that, I don't intend to address any of the matters.
I see. Right. Very well. Yes.
Could I just say, sir, that I hope that today's preliminary hearing has been regarded by those who have attended, whether in person or remotely, as informative, comforting and hopeful. I and the rest of the inquiry team look forward to advancing the inquiry's investigations in the coming months and to working with core participants in the clear, open-minded collaborative and trauma-informed spirit which our stated principles demand. Thank you.
Thank you very much. May I also address myself to all who have attended in person at today's hearing, or indeed from a remote location, and reiterate my thanks for your interest and for your attendance today. I do hope that you found the discussion helpful, even illuminating, as might have been apparent from Mr. Dawson's contribution. I personally am very anxious to build and maintain momentum now that we advance into the inquiry's evidential investigations. I do ask you please to bear in mind what was said by both myself and Mr. Dawson about engagement with the list of issues, which I conceive to be a very important document which is available to you on the website. Please expect to hear regularly from the inquiry, and we will of course meet again, as has been previously stated, in the month of November. Finally, can I also reiterate my thanks for the written contributions, and to Mr. Dawson, to Ms. Cherry and to Mr. McGilvray for their submissions this morning and this afternoon. To those of you who have travelled, I wish you a safe journey home, and the hearing is now adjourned. Thank you.